Thank you. With that, we go to the gentlelady from California, Ms. Lundgren.
It's Lofgren. Thank you very much, and thank you,
Zoe.
Ms. Perlmutter. First, just a kudos for the modernization efforts. I know we're not done yet, but we've made great progress. I want to thank you and the librarian as well. Just a note on music modernization. I really think that was a triumph of collegiality and cooperation, but there's a few bumps in the road, and part of it may be our fault, but in terms of the songwriters, I'm hoping that you can make an extra effort to reach out to them because of what Congress did, because we want to make sure everyone is heard, and I know you believe in that. I want to talk about right to repair. We haven't talked that much about Section 1201 as in terms of reform, and I raise that with some trepidation because people who have content worry, and I understand that. If you have a software tool that protects content, if it protects a movie, if it protects your song, if it protects your book, if it protects your visual art, you shouldn't be able to break that. So I'm not suggesting that. However, if you're using a software tool to protect something that isn't content, which is what you've addressed, that's a different situation. And I'm wondering, I mean, you can legally fix your tractor now, but you can't get the software that allows you to fix your tractor under 1201. So I'm wondering if we could craft a narrow exception that would not cause any concern among the content community that is specifically, narrowly, and unequivocally only directed towards right to repair. Do you think that's possible to do? And if so, would you help us?
Yes, I do think it's possible. In our office's report a couple of years ago on Section 1201, we noted that we had been recommending and the librarian had been issuing exemptions to permit repair in certain circumstances, and that it might make sense to have a permanent statutory exemption so that this didn't need to be revisited every 3 years, and we would still support that.
You know, we do have the triennial process for 1201 exemptions, and I want to thank you. I mean, when we did 1201, and I was here in the Congress when we wrote it, we didn't intend to allow cell phone companies to protect their monopolies. It was about protecting content, not you know, tractors or cell phones or other equipment. You have a lot of work to do, and I appreciate that you're not asking for more staff, but if we were able to either streamline the 1201 process when it relates to non-content issues or create a narrow exception that protects content, wouldn't that help relieve the workload in your office?
Yes, I think there are several areas where 1201 could be amended that would make the process easier. And I have to say, I was around also when 1201 was written.
Yep.
And the idea of the amount of work it would require terrified me at the time. We've learned how to handle it, but it is a lot of work.
In terms of right to your person, you've talked about that, and it's really state law publicity about yourself. I think it's important that we take steps more urgently on that, given artificial intelligence is already here, and people are going to need to take action to protect their appearance and their personhood in AI. We don't have a statute, I think, in mind yet, but I would very much welcome and ask for your assistance in crafting something that would provide that protection, but more importantly, that would think through how we might give people an easy avenue to enforce that right. Because AI is massive, it's here, it's not going to be stopped, and yet the potential for people to have their personhood misused is real, already here, but having a right and being able to enforce that right are two different things. Do you have comments on that?
We would be happy to assist in drafting.
I appreciate that very much. We will follow up with you. And, Ms. Chairman, I yield back and thank you.
And I thank the gentleman.